Thank you, Nicola, and probably I should say more contentious lately rather than non-contentious, just the current market and the way things are. So today I've been asked to talk about transparency and whether transparency is the new religion in public procurement. In arranging how we were going to do this, I did speak to Nicola's colleague Curran. She was going to cover a post-tender process and debriefings. I'm going to cover transparency in the tender process. So Nicola, I don't know if you're going to mention maybe debriefings and things like that, but I'm just going to focus on the in the procurement process and particularly the evaluation process. Now, as you all know, in the directives, there are provisions already that ensure levels of transparency. So, for example, there is the obligation to advertise, there's the obligation to use certain procedures, there's the obligation to look for certain information when you're pre-qualifying, obligation to publish selection and award criteria, and then obligations to give information to unsuccessful bidders after the tender process. So obviously there are provisions in the directives at the moment that give a level of transparency. But in the last decade or so, we've seen probably a new range of cases, principally relating to service concession contracts and Annex 2B contracts, i.e. non-priority services contracts that have a cross-border element. And we've seen the European courts using these cases to develop the principle of transparency and to develop the obligations that apply to contracting authorities in terms of transparency when awarding those contracts. And the principle of transparency there stems from the treaty on the function of the European Union, which is the current treaty that we operate under, and the general free movement provisions in there, which have been used by the court to derive various general principles including equal treatment, proportionality, mutual recognition, and what we're going to focus on today, the principle of transparency. So I'm going to look at a number of things today, as I said, focus primarily on evaluation. First of all, what does transparency require? How do we ensure transparency in the evaluations? What can be evaluated? How do you formulate your award criteria and so on? What must be published? And then finally, I'm just going to focus on a couple of cases, one from the UK and one from Ireland, which demonstrates how the courts approach this issue of transparency in the evaluation process. Just by, again, way of introduction, again, what does transparency require? Well, it requires various things, but in summary, first of all, it requires a level of advertisement. So we all know about the seminal case of Tele Austria, which was related to a services concession contract, and there the court said that the principle of transparency consists in ensuring, for the benefit of any potential tender, a degree of advertisement sufficient to enable the services market to be opened up to competition and the impartiality of the procedures to be reviewed. So clearly the court is saying there that transparency requires a level of advertisement. Now, does that advertisement mean that you have to have a tender competition? And again, this was addressed in the Konami case, and there the court said that it didn't necessarily mean that you had to have an invitation to tender. The award of the concession complies with transparency requirements without necessarily implying an obligation to hold an invitation to tender, such as to ensure that an undertaken location in another member state can have access to appropriate information regarding that concessionaire before it is awarded. So here they're saying that if you have some form of advertisement which allows an entity in another member state to be able to express their interest, well, then that would be sufficient. You don't necessarily have a tender competition. That would seem to be implied to me that really what the Konami case was saying, that while you don't have to have a full-on tender competition, you do have to have some form of advertisement, maybe inviting people to express an interest. If you don't get any expressions of interest, well, then you can go ahead and award the contract as you deem appropriate. But it is some form of advertisement inviting expressions of interest. With regard to the description of the subject matter and the award criteria, again, the court used the principle of transparency in the Commission versus France case to say that the principle of equal treatment and the principle of transparency which flows from it requires the subject matter of each contract to be clearly defined and the criteria of its governing to also be clearly defined. And then finally, with regard to the duty to give reasons, there's been a number of cases on this. The serial litigant at European level excuse my Greek, Ivropaki, Dynamiki, also Ivropaki apparently in Greek refers to European, so European Dynamiki, who's had, I think, approximately 15 cases against community institutions. They In this particular case, issue about whether there was a duty to give reasons, the court said principle of transparency, which informs every public procurement, requires that particular care is taken when a candidate's tender is rejected with the statement of reasons. So you have to take care with your statement of reasons, and this is required by the principle of transparency. So I think that's really what principle of transparency requires, and there's lots of cases on this, and each of these principles and areas could be developed even further. But today, as I said, I'm just going to focus on the area of evaluation and how much transparency is required around the evaluation. Just before I get into it, I have a number of clients who operate in the private sector, and they often are amazed by the requirements on contracting authorities in terms of what you have to disclose with regard to the evaluation process. As we all know, if you're operating in the private sector and you're not falling within the European the Utilities Directive, you can develop your own tender procedure. And a number of entities operating in private sector today would use formal tender procedures to award contracts, but in terms of what they have to disclose and what the courts have said that you have to disclose, there is, I guess, a level of amazement as to how deep the courts have gone in terms of what the level of transparency is required in regard to how you conduct your evaluation process. Just again, then looking at the evaluation process, I guess one of my first points is that it's one of the most common grounds for challenges. As I said, it's a very contentious market at the moment. There's lots of cases out there, and I don't think that I have ever been involved in a challenge where there hasn't been an issue raised with regard to evaluation and in regard to the transparency of the evaluation process. And you might ask yourself, why is that the case? And I think there's a very clear reason why that is the case, and it's to do with the limitation period or the review period for challenging in the courts. And under the Irish regulations, and indeed under the new regulations in the UK, the time frame for challenging is within 30 days from the date that the unsuccessful bidder knew or ought to have known of the alleged infringement. So it's a very, very short time frame for bringing a challenge. So if a bidder knew or ought to have known of something that was signalled in the tender documentation or indeed earlier in the process, they'll generally be out of time by the time that they're notified of the award decision. And it's only really, they will only become aware of an issue in terms of how their bid was evaluated or indeed how the successful bid was evaluated, probably at the date that they're notified of the decision, because they'll be given the characteristics and relative advantages, and those characteristics and relative advantages will generally contain comments about how the evaluation was conducted. And if they aren't informed at that stage, well, then it might come out subsequently in debriefings or even further on down the line as there is correspondence between the contracting authority and the unsuccessful bidder. So that's the main reason why transparency in the evaluation process is a very common ground, a common issue in challenges, and something that we as lawyers probably see every day in terms of looking at challenges. So then moving on with regard to what can be evaluated. I'm not going to go into this. I think you all probably have a high level of familiarity with what's in the directives, but clearly there's rules as to what you can evaluate at award stage. You, in terms of the award criteria, your award criteria can only be lowest price or most economically advantageous tender. Your criteria under the most economically advantageous tender must be linked to the subject matter of the contract. The weightings must be specified, and we've already heard about Leonicus and the fact that experience can't be an award criterion. So really your award criteria are the cornerstone of the evaluation, and that's where the transparency has to be at. As I said, it's common ground for challenge. The types of grounds that you would see in any case with regard to an unsuccessful bidder attacking the transparency of the evaluation are listed there on that slide. For example, award criteria were not applied in the manner set out in the tender documentation. There were undisclosed award criteria or sub-criteria taken into account. Undisclosed weightings were applied. So, for example, while the contracting authority may have put in the weightings for the award criteria, they may not have put in the weightings for the sub-criteria. or they may have even developed further sub-criteria and didn't put in weightings for those. So again, that might be a reason to challenge. There was information taken into account that wasn't disclosed in the tender documentation, or bidder information was evaluated under the award criteria, which gets to the Leannica's point and the fact that you can't, for example, assess experience at award stage. There's a very large body of case law around this area, and I'm going to probably focus on the seminal cases here. One of the most seminal cases, and really the bedrock for a lot of these challenges, and we often see much quoted, is the SIAC case, SIAC versus Mayo County Council. And here the court it looked at the award criteria from different perspectives, and set out the requirements of transparency in regard to those award criteria. From the tenderer's perspective, the court in SIAC said that equal treatment and transparency required the award criteria to be formulated in such a way as to allow all reasonably well-informed and normally diligent tenderers to interpret them in the same way. So here, this is the standard of review for looking at your award criteria. How would a reasonably well-informed and normally diligent tenderer have interpreted those award criteria when reading them? From the contracting authority's perspective, the court has said that the transparency principle requires the contracting authority to interpret the award criteria in the same way throughout the entire process. So you've got an obligation on the contracting authority to interpret them in the same way in the entire procedure. And then in the assessment, the award criteria must be applied objectively and uniformly to all tenderers, again bringing in elements of the equal treatment principle as well as transparency there. So the standard of review, therefore, is that, as stated in the SIAC case, how would a reasonably well-informed and normally diligent tenderer have interpreted the criteria in the tender document? Now, there has been a further case, ATI, which again, a seminal case I'm sure you're all familiar with, and all of these cases, I've done a much more detailed paper, but all these cases are set out in the paper. ATI took the standard a little bit further and said that in terms of publication of the award criteria, and this case related to the sub criteria and sub weightings that had been developed for the sub criteria post tender, the deadline for tender submission, but actually prior to the opening of the tenders. The court said that in terms of whether or not you're obliged to publish those sub-weightings, there are a number of elements. There's basically a three-stage test you need to engage in terms of determining whether or not you should have published those sub-weightings. And the three limbs of that test are as follows. First of all, would the sub-criteria weightings alter the published criteria? So if you're developing sub-criteria or sub-weightings that may publish the criteria that you've published in your tender documentation, well, then they need to be disclosed. Second, would the disclosure of the sub-weightings or the sub-criteria have affected the preparation of the tender? So if you're developing new sub-criteria or new sub-weightings, could that have affected the preparation of the bidder's tender? Now, this is a very important element, and we'll see that this has been used in a number of cases to basically overturn a contracting authority's decision on the basis that they didn't publish the sub-criteria, the sub-weightings. From my own perspective, I think that it is seldom that you could say that if there was a new factor or a new sub-weighting brought into in the evaluation, that you'd say that couldn't have affected the preparation of the tender. Normally, in any case, an unsuccessful bidder will be able to show that they would have or that they could have amended their tender submission to in order to obtain further points if they had known about that sub-criteria sub-weighting. And finally, were the sub-criteria weightings likely to give rise to discrimination against one of the tenders? If that's the case, well, then they should be published. Now, again, I apologise for a long quote, but this is such a beautiful quote, I had to put it in. It's a quote from Judge McCluskey from a Northern Ireland case in January as to what does the standard of a reasonably well-informed, normally diligent tenderer mean. And I think there's some good language here and good indication of what that reasonably well-informed and normally diligent tender is. First of all, With regard to his or her characteristics and attributes, they're normally not necessarily fully informed and usually careful and attentive, but not invariably a paragon of diligence. So they don't have to be absolutely, paragon of diligence, just reasonably informed. A tender who may be vulnerable to a certain, though not excessive degree of error, inattention and other human weakness. SIAC, hypothetical tender, is a terrestrial rather than a celestial being, hailing from earth and not heaven. The court should approach the matter not as an exercise in statutory construction or as one involving the interpretation of a deed or contract or other legal instrument. To adopt such approach would not be consonant with the SIAC test. Rather, the court's intention must focus very much on the industry concerned, in which the professional and practitioners are not lawyers. So that gives you a view as to what is the reasonably well-informed and normally diligent tenderer. Remember, it's normally the lawyers that are looking at the comments in the debriefing letter and creating the challenge in terms of, for example, a High Court challenge. And the court said that's not what the standard is. The standard is how would the reasonably well-informed, normally diligent tenderer in this tender process, in this industry, have approached the interpretation of the tender documentation and approached the interpretation of the award criteria. Again, the ATI test has been brought out in a number of recent cases. And again, we see our old friends, European Dynamici, here again. And here we can see in these cases from the European, from the General Court and from the European Court of Justice, that there is a level of flexibility in terms of sub-criteria and sub-weightings. And really, the issue is whether or not you are triggering the ATI test in terms of whether or not you're obliged to disclose. So in this case, which was a case against the European Maritime and Safety Agency, the agency had developed sub-criteria, but here European Dynamici hadn't shown that this had triggered the ATI test. And just a couple of quotes there. The applicant, by merely referring generically to the fact that the contracting authority subdivided a criterion into two sub-criteria, has not shown that the decision led to an altercation of the contract award criteria, or that it contained elements which could have affected preparation tender or gave rise to discrimination. So just by merely stating or showing that somebody has subdivided the sub-criteria is not enough. You have to show that any one of those limbs of the ATI test has been triggered. And again, in the Court of Justice, in dismissing the appeal, the court said that there has to be some leeway in carrying out the task. Accordingly, it may amend the contract award criteria, the structures work examining and analysing submitting tenders. Again, this is provided you don't trigger the ATI cases. So there is some level of leeway there. Just a quick focus on a couple of cases at national level. The Mears case, which was a case in 2011 with regard to a challenge to a tender competition for capital improvement, refurbishment and maintenance of social housing in Leeds using a competitive dialogue process. This was a very, very large tender competition with a value of 420 million sterling. There were two award criteria, price and quality, 60-40% split. And quality was assessed by reference to 8 criteria, and each of those criteria were weighted. And then those criteria then were assessed by responses to various questions which had been posed under each of the criteria, and those questions weren't weighted. Leeds developed internal scoring guidance and model answers which weren't disclosed to the bidders. And the guidance did suggest that full marks could only be achieved under these criteria where there were innovation, where there was innovation or where it exceeded the specification. So Mears claimed that the questions constituted criteria and should have been weighted, and that the model responses also constituted criteria, and the internal guidance as well should have been disclosed. Now, it's a very helpful case, and that's why I referred to it, because it actually summarises all of the cases that have gone before this, summarises Lianicus, Universal Bow, ATI and so on, and indeed the national cases in the UK. And the court in paragraph 122 summarises the law as follows. First of all, the contracting authority has to disclose Those award criteria or sub-criteria which it intends to apply to the award, pretty straightforward. Contracting authorities obliged to disclose any rules for the relative weighting of the selection criteria. Contracting authority could attach specific undisclosed weight to the sub-criteria by dividing among those sub-criteria the points awarded a particular criterion, provided that the ATI limbs are not triggered. There is a distinction between an award and selection criteria, which is the Lianicus case. There's a level of assessment below the sub-criteria, the criteria and the weightings, which the contracting authority may use in evaluating the award criteria, which it doesn't have to disclose, again, provided that it doesn't trigger the ATI test. With regard to then the actual specifics of this case and whether the model answers and so on should have been disclosed, the court held that the unweighted questions amounted to sub-criteria and should have been weighted, as bidders may have prepared their bids differently. So here they were relying on the ATI case to say that if bidders had known about these sub-weightings, they could have prepared their bids differently. With regard to the internal scoring guidance, they said it was guidance only and it didn't need to be disclosed. And interestingly, with regard to the fact that you had to be innovative or exceed the specification, the court didn't think that that needed to be disclosed because this was a competitive dialogue process and there was a level of innovation anticipated in such a process. So I think that's an unusual part of the judgment. With regard to the model answers, the court really went through a very comprehensive review of the model questions and model answers and found that there were two model questions that if they had and model answers, if they had been disclosed, could have affected tenders preparation, and therefore the court felt that those model answers should have been disclosed. Court found that there was a real or significant likelihood that Mears could have been successful if there had been proper disclosure, and the court, rather than setting aside, decided to award damages, and there were a number of reasons why they didn't award the set aside, but I'm not going to go into that, and damages were awarded. Similar case in Ireland, release speech therapy versus the HSE. In that case, the Health Service Executive, which is the Irish equivalent of the NHS, had awarded a framework agreement for speech and language therapy services for children aged 0 to 5. So this is for children, for example, children with special needs who need to have speech therapy from a very early age. And the Health Service Executive was looking to put in place a service provider to meet those needs. There was only one bid received, and that bidder only offered group therapy services only. Now, in the tender documentation, there was no mention of group therapy or individual therapy services. There was no requirement that you had to be a provider of individual therapy services and group therapy services, although there was a requirement that you had to be able to take a holistic approach to the children and to be able to meet their needs. And the court, again, in looking at the standard of reviewing it, looked at it from the SIAC perspective, the reasonable and normally diligent speech therapist provider. And the HSE brought in an expert to show that the tender requirements, in her view, really clearly specified that a range of services were required to treat these children, and group therapy services would not have met that requirement. And again, if you look at it from a child's perspective, say a child with special needs, 3 months old, how could you provide speech and language therapy services to a child of 3 months old in a group therapy session? It would really have to be really in an individual therapy setting. The court, again, also found it was quite important that the tenderer here had said that its bid was non-negotiable. So even if it had known that group and therapy, individual therapy services required, it really wasn't going to offer ever individual therapy services. So it was only ever going to offer group therapy services. The fact that it was a framework agreement, the court didn't think was relevant, because here there was only one bidder who had bid for this contract, and in that circumstance the HSE had to deal with the scenario, and then the court held that there was no breach of the principle of transparency, and that this requirement with regard to individual therapy services and group therapy services didn't need to be mentioned, specifically mentioned in the tender documentation, or to be disclosed in an award criteria. So just in summary then, what must be published? I think it's clear that if there is any element or factor that may have an influence or impact on how bidders will prepare their tenders, well then it must be disclosed. So for example, with regard to sub-criteria, sub-weighting, scoring methodologies, scoring systems, tender returns, model answers, all of these need to be disclosed if they could affect the preparation of the tender or indeed trigger any of the other ATI principles. Just again in summary and just highlighting some of the points of the presentation with regard to the timing, which is a real issue in terms of whether or not an unsuccessful bidder can challenge. You have to focus on whether or not the criteria, the sub-criteria, the lack of weightings could have been alluded to in the tender documentation. So, for example, if there were sub-criteria there and there weren't weightings there, well then maybe it might be possible to bring an application to have the case struck out on grounds of delay, because it would have been clear to the unsuccessful bidder that there were sub-criteria there were no sub-weightings there, and they're out of time to challenge the fact that sub-weightings may have been attributed to them subsequently. The complainant, however, is more likely to be successful if it is clear that a new criterion was taken into account and that could have impacted on tender preparation. It wasn't alluded to in the tender documents. The complainant will need to be able to clearly demonstrate how it could have affected the preparation of its tender if these criteria had been disclosed. I would say that in terms of Annex 2B services and concession contracts which have a cross-border interest, then the disclosure obligations are probably as strong as they are for contracts falling within the directives on the basis of the principle of transparency. With regard to below threshold contracts at national level, there are administrative principles at play. So, for example, would it be reasonable not to disclose criterion, sub-weightings and so on? And could that be challengeable from a public law or administrative law perspective? And then I think best advice is always err on the side of caution. If you think it should be disclosed, then disclosed. Is that it? Yes, there you go. Transparency, your religion. Thank you.